All right, now let's discuss the parliamentary impeachment inquiry into Mkhwebane. We're now joined via Zoom by legal analyst Mpumelelo Zikalala. So thank you so much for your time this afternoon. Now, let's discuss this matter. If the parliamentary impeachment inquiry chairperson, Qubudile Dyantyi, does indeed recuse himself, is this likely to have any impact on the outcome of the impeachment process?
Afternoon to you and also to your viewers. Yes, it's going to have an impact because it then means that this particular inquiry must start day now, meaning that all the evidence that has been presented before must start from scratch. All the witnesses that have been called must be recalled at the end of the day, because it would have meant that while they were presiding or giving their evidence, the presiding officer was presiding over those proceedings with this element of biasness being there. But we have to go back and check what does it exactly mean when it comes to the element of biasness. It must then mean that from the side of Advocate Mkhwebane, it must be clear that there's no doubt that the presiding officer is going to judge her matter impartially, without any favors, and simply deal with the evidence which is in front of him without any fear or favors. Now, if you choose to align yourself with any aspersions or any cast or objection or things which are going to give an impression that you've already made your decision, the impression which is made from the side of the presenter or Advocate Mkhwebane is that you've already decided on this particular matter. No matter what I say, you're going to change your mind. And on that basis alone, then our law says you must be recused, or you must recuse yourself as the presiding officer and allow someone who's going to be independent to take over from you.
In fact, they have discussed, of course, the questions around credibility and, the integrity of this inquiry. So, Advocate Dali Mpofu maintains, that Parliament issuing out that media statement that we saw welcoming the Concord ruling and the personal costs order against Mkhwebane shows that the parliamentary impeachment inquiry is not fair and it's not reasonable. What do we make about these assertions, and are they valid?
It can be raised, but when it comes to validity, maybe another perspective can then come in. We must then look at who is the decision maker in this particular process. Is the decision maker the person that issued the statements that you are referring to, or is it a process of that a spokesperson within Parliament sat down and said, this is what is going to happen at the end of the day. This is the statement that you are issuing, which will go out to the members of the public. However, the decision makers have not disclosed exactly what they think of Advocate Mkhwebane. They're not casting any aspersions on Advocate Mkhwebane. So the next question, or the important question element, would be, who issued the statement? Who are the instructors of that particular statement? If those instructors of the particular statement are the decision makers in this process, then certainly I don't think that this application is going to succeed. One may even think that when this process, if it is recommended that it does so, when it moves on to the National Assembly, even one can have a reasonable suspicion that Parliament is going to take a dim view based on what has been issued. But let's also remember that the National Assembly members are independent thinkers, or we'd like them to be independent thinkers. They take decisions on their own, and they don't take decisions as a collective. So if it is proved that whoever issued that particular statement is not the decision maker who is an important player in this case, then I don't think the application for recusal is going to succeed.
Help us unpack then the testimony that we have been seeing, over the past couple of weeks. In fact, over the past couple of days, we're also hearing how the suspended public protector was, for the most part, very abusive, to her staff, and not a very compassionate leader. And of course, on Thursday, we heard, some of the information around the SARS rogue unit investigation and the report that she based her information on. Just help us unpack about what we are currently seeing now in terms of what can we make about the utterances being made by some of the witnesses.
I think what the witnesses are trying to draw up, let's remember the only time in which you can impeach a public protector is if you have found the public protector guilty of misconduct or incapacity or incompetence. So if all those pieces of evidence which keeps on coming in are able to help that indeed we had a public protector, or we have a public protector who is incompetent or engaged in allegations of misconduct, then it's going to bolster the case of saying that we find you guilty in those particular proceedings. But before we conclude on that, we must then hear the side of the public protector, her response, and not only that which is being stated with the versions which have been put through by Advocate Mpofu. So up until Advocate Mkhwebane has really went into the witness box, only then you can be able to come to a determinable sort of conclusion of saying that indeed you did engage in acts of misconduct and incapacity. Another process or another thing that you must also remember, one would then ask, why didn't you engage internal processes which existed at the time, which would have yielded immediate results or immediate justice if indeed you had done by what had happened to you? We can never have a superhuman public protector who's not going to make mistakes. We can never have a superhuman public protector who's going to do things right all the time. But what matters the most is that those instances of misconduct, are they gross? Those instances of, let's say, the miscommunication or non-alignment as to the instructions that are they such of gross manner in which they will then lead us to conclude that these particular acts or allegations are indeed misconduct allegations. If they are not able to prove that, then the chances of them finding the public protector guilty of misconduct and incapacity or incompetence are going to be very slim. But I think we can only come back to a reasonable conclusion of all these pieces of evidence that are coming in after the public protector has presented a case.
All right, Mpumelelo, thank you so much for your time this afternoon. Really do appreciate your time. Mpumelelo Zikalala, the legal analyst.